Hi, and welcome to Overtime, LIASB's online business development series. Tonight's program, running your business and dealing with commercial contracts. Our guest tonight, Francine Love of Love Law Firm, PLLC, and Elliot Portman from Portman Law Group, PC. Welcome to the show, everybody.
Thank you.
Nice to be here, Fred.
Excellent, excellent. Well, before we get started in regards to the questions that have been, submitted by people in business or things that we're going to be talking about tonight, why don't you, quickly just give us a little bit of a background on each one of you. Francine, do you want to go first?
Sure. I'm Francine Love, and I'm the founder and principal attorney at Love Law Firm. And what we do is focus on helping entrepreneurs and small business owners succeed. We do everything from helping them start their business, from picking the right corporate entity, to ultimately selling their business so that they can retire and enjoy the fruits of their labor. And if there's anything that happens in between, we're there to support. So that's a little bit about our firm. I've been a practicing attorney for more than 25 years, worked with a number of major clients as in-house counsel, and have a vast commercial experience working with businesses end-to-end.
Excellent. And Elliot, yourself?
Fred, I've been an attorney for 30 years. My primary focus is assisting creditors with the collection of their accounts receivable. I'm a member of both county, state, national, and international organizations regarding the collection of outstanding debt. My office is located in Hauppauge, but my clientele is all around the world.
Well, interesting. Very interesting. All right. So take me with you the next time you go to Tahiti.
I wish.
All right. The reason I wanted to have both of you back again, both of you sat on a panel in one of our monthly meetings a couple of months ago, and there was a lot of, what I want to say is, questions that the audience had in regards to some of the points that you were bringing up as far as either running a business, how to deal with commercial contracts. And we also had another guest, Sean McGowan, who was actually a guest speaker at our new entrepreneur group this past week as well. But what we want to talk about today is, as far as running a business or commercial contract, it's going to kind of focus on a couple of different things in the area of, risk, employee theft, how to deal with, collections, and also contracts with, employee contracts, and then some of the pitfalls that go along with that. So we're going to run through a couple of different things. And first thing is as far as dealing with theft, what do I ask an employee who is suspected of theft or a serious policy violation? So how should a small business address that initially when dealing with an employee? Elliot, you want to take that first?
Sure thing, Fred. The first thing you have to know is what kind of theft or fraud we're talking about, because this theft can take many forms. It can be larceny, outright theft, skimming, diverting business funds, fraudulent disbursements, embezzlement of raw materials or inventory, or stealing business opportunities. And when you're speaking with this person, first identify what kind of theft we're talking about. And as you speak with the person, the attitude that you take in the interview and the manner in which questions are put to this employee have a lot to do with eliciting cooperation. So what we want to find out here is, how long has this been going on? Why is it going on? And are there any other employees involved? Probably the first thing you want to do is speak with an attorney, your own attorney, to say, hey, I've got a problem here, and how should I address it? I have to say that because we're attorneys. what we say.
Okay. So it does seem that I guess the tactic that a person should take will vary based on the type of theft or violation that is being investigated.
I think the questions are the same no matter what kind of theft we're talking about. Your approach may be different depending on whether it's, for example, the bookkeeper, where you found that funds have been diverted, versus the person on the shop floor who's been putting a wrench in their pocket every day for the last week.
And to that, policy violation versus theft. So I would imagine the business owner, a small business, he may be the only person, or he may have a team of people like an HR director or an operations manager, CFO, or somebody like that. But I would also imagine that it would be better for that interview to be done with those heads of those departments as well. So like if it's a policy violation or an HR violation, have the HR director there or somebody who is familiar with HR policies in that meeting as well.
My recommendation is that none of these interviews be conducted one-to-one. There should always be a third person in the room. And that's primarily to protect the business.
And if I could add one of the things that enhance one of the things that Elliot said about the importance of seeking legal counsel. If you're in a situation like this and you have someone who's stolen from you, you could very well want to tell them, I'm going to call the cops on you. You have to be very careful. Threatening criminal charges can be viewed as extortion and can actually lead you to have a problem. And so you want to be very careful with how you go about confronting the person with what's happening. You can always threaten to sue them to recover the money, but threatening criminal prosecution can actually get you into trouble. If you're going to call the cops, call the police and initiate the investigation that way. But be very careful. Seek legal advice before you go about doing something like that, especially if it involves a theft of money, and if it involves theft of client money, then you really want to bring in legal counsel.
Very good. Very good point. Thank you very much. All right, so that's kind of leading into the next question. What basic audit steps should be implemented to help prevent theft with the company? I would imagine, if something happens within an organization, those audit steps or those steps help uncover where you need to go and what should be done. Am I wrong in that thinking?
One of the things that you can do is, if we're talking about somebody who handles money as being the suspect, you want to have two eyes on the books. If you have an in-house bookkeeper, you want to have an outside accountant who is reviewing the work on a at least monthly basis. Some of the things that you can do if you're in you manufacture parts and you send out invoices, you want to make sure that you receive purchase orders from your customers so that there's something to compare your invoice to. One of the schemes that bookkeepers use to divert money to themselves is to create fictitious customers and write the business checks to themselves for their fictitious businesses. In terms of audits, a physical audit. How about random audits? Rather than saying, okay, we're going to go through the books once a month on the third Monday. Change it up a little bit so that there's a little bit of unpredictability that month. One of the things that you want to do as a business owner is to keep on top of your business checks. Always use pre-numbered checks where the pays and the amounts are typed as opposed to handwritten checks, which take a lot less time to generate. If you talk about the theft of product from your floor or your warehouse, have good audits, inventories, and keep them up to date. So by approaching the problem from a preventative point of view, you may avoid theft in the workplace.
Mm-hmm. Okay. In dealing with businesses, I'm sure, money is probably at the top of the list as far as where, most steps come into play. As far as, what's the hardest thing to audit within a business as far as, trying to prevent theft? Are there any, major things that, a small business should look at, or is it really dependent upon what they're doing, whether they're selling a service versus selling a product?
If you're selling a service, chances are the service is concentrated on just a few people. If you ask me the toughest thing to keep an eye on, it's your employee's relationship with the customer. Are those employees trying to siphon the customers off for their new startup business? If you have product on the floor, you have an inventory and you can keep an accurate count. When you have services, well, then it's where the service providers spending their time. How do you track that? There are software programs available so that the employee would have to check in, ping the server, so you had an accurate location of where they are. I mean, time can be stolen as well. Somebody goes out on a service call and winds up going to the beach. It's an extreme example, but here they are sitting on the beach getting paid.
Yes, I was just thinking about that as far as, their employers, either pay based on hourly services or whatever that is, or compensate, employees based on the time they're allocating to specific jobs and things of that nature. And there's, we hear a lot of things as far as, we'll find apps put on tablets or phones and GPS tracking and things of that nature to help the business owner track and manage that time aspect so that it doesn't get out of control.
There are whole industries based on that. Putting the GPS units in the trucks.
So I guess if a business owner has a problem with certain things and it's kind of like a repetitive issue, then they really should seek somebody or some advice from a specialist in regards to implementing, whether it be, software or physical solutions that can help avert those problems and mitigate their risk.
Absolutely.
And I recently taught several classes about employee privacy rights. So before you put a GPS on a car, you want to talk to someone like me who understands whether or not that violates their privacy rights. The short answer is if it's your car, a company car that you've provided to them, you can put a GPS on it and track them all the time. But if you're wanting to put it on a personal auto that's being used for deliveries or for other types of events, you want to be very careful about doing that, or using a BlackBerry or a smartphone to track whereabouts of people, because there are times when some, believe it or not, there are unethical employers who have tracked their people at all hours and used it to harass people and do bad things. So there are laws preventing some of that. So you'll want to talk to an attorney to help you understand the right balance of monitoring to protect your business and at the same time not being too overzealous.
So a company that has field employees and they're bringing their own devices, we hear that term, bring your own device. So whether it's using tablets or their phones, even though the company is providing the app on that individual's property for them to use and interact with the business, there are limitations in terms of what the business can do there in terms of tracking that employee.
Correct.
Okay. That's interesting. I know a couple of people that I should have to call you right away.
Excellent. They're welcome to do so, Fred.
Okay. So the next topic that, or subject that came up is what can be done, and we kind of just started talking about that really as far as some of the things people can do is, but what can really be done to prevent theft and crime in the workplace? And one thing that I kept hearing about, I mean, we can put in all these other things, and you guys are going to elaborate on that, but the one thing that I heard was engaging and training the employees. And I wanted to hear from you guys as far as how much that might also play in terms of preventing crime, or is that one of the pieces that we can put to the pie of helping to prevent crime in the workplace or theft?
Well, my opinion on that is that employers should have a plan, should have a fire plan, should have a theft plan, should have a crime in progress plan, all of which probably involve the first call being to the fire department or the police. But I think an employer really has to come up with a safe environment for the workers to the extent possible. And crime in the workplace can come from the outside, and it can be employee-on-employee crime. And a lot of it can't be predicted, but an employer should be looking for telltale signs of an employee being disgruntled, if we're talking about inside. Or if there's been a rash of crimes in the neighborhood. If you have a storefront and a lot of the stores around you have been broken into, you can't do anything at night other than lock the doors, put on the alarm. During the day, you run the gamut between mischievous children who run in and snatch candy all the way up to somebody with a handgun walking in. There has to be a written policy that the employer can point back at and say, we try to anticipate as best we can. But the reality is you can't prevent 100% crime.
So the best thing to do is do your due diligence and try to be as forward-thinking as possible. If an act is possible and it applies to your type of business, then more than likely it can happen. So address it now versus later and be sorry later. It's very interesting, in terms of there's one thing that you also said, documenting, and we hear that a lot lately, on all the subjects that we talk about. Like we had a show on compliance, and a lot of it was about, documenting the process that the business and the employees have to perform or do in the event of something happening. And that becomes very relevant in regards to, I don't know, whether it's maybe an insurance company processing, a claim or whatever the case is, or the authorities investigating something, or a federal agency. But it seems to come back to the more you have documented the process and have a plan for your employees, the better you are as far as defending against, risk and hazards that come into play with the company. So I would assume that also applies to theft and crime as it would compliance and regulations, correct?
Well, you have attorneys on the panel tonight, so we're going to tell you that we look at things from a litigation perspective, not exclusively because we care about your employees, but from a litigation perspective, you want the employer to have a written plan in place that all the employees are supposed to know about. Perhaps it's part of their employment manual. And that way yes, you can look back and say, we did all the things anticipating as best we can. And when the event happened, we did everything according to our plan.
Okay.
You know, the best of all worlds.
And you may have a side benefit from doing this, from putting in these plans, besides the fact that you have defenses available to you later if, God forbid, something happens. But in the interim time, by having these plans and policies, procedures, you can tell your insurance company that you have this, and oftentimes you can see a reduction in premium by being able to show that you have good risk management processes in place, because you're a far better client for them to have than someone who doesn't have that. And so what we're saying isn't just about costing you money. It could ultimately help save you money, not only in the long run when something bad happens and you now have this ability to respond to it, but you could also potentially save money in the interim by lowering premiums on insurances that you're required to carry.
Very good. Very interesting. That makes sense. That actually makes sense. Very good. Very good point there. All right. So now, what can I do when someone doesn't pay for services or pay for a product? So, what can a business owner do legally? But more important, I think, is what shouldn't they do?
Well, I'll answer that. That's what I do. What they shouldn't do is give up on the claim. I have a lot of clients who initially are reluctant to put a customer into collections. And they say, oh, they'll never place with me again. And my answer to them is, they owe you $50,000. They're not a very good customer, are they? Because if they're a good customer, they'd be paying you. But no, you've come to see me, and let's talk about the different things that we can do. I think that to minimize damage in terms of receivables, you have to stay on top of them and be on the lookout for clues that your customer isn't going to pay you, like a sudden drop in communication. You could be the best of friends, you start this business relationship, you play golf together, tennis, whatever, and suddenly they won't take your call. Or you have a new dispute over old invoices. 6 months have gone by and you've sent bill after statement of account. There's been no complaint, and then suddenly there was something wrong with the product or the service. You have broken promises of payment. We'll send you a check next week, and it never comes. Or it comes in and it bounces. And ultimately, if you pick up the phone and you call your customer and the number's disconnected, don't give up, because a lot of times businesses just don't go away. They have receivables, they have physical assets. Go pursue it. If you want to engage a professional like myself or go to small claims court, do it. Don't walk away from your own money.
Okay. Very good point. And I think a lot of people do that. They get frustrated or just, bogged down with the day-to-day putting out fires that, they tend to let things go past the time and not look back in terms of doing things. Now, somebody brought up a question as far as, let's talk about the internet services or web services or things that are done, online. If you have a client that isn't paying their bill or hasn't paid a bill, can you cut that service off without any repercussions because they haven't paid?
Well, hopefully you have a written contract that says you can do exactly that. In the absence of a written contract saying you can terminate services if you don't get paid that month, then you have to look at what's the nature of the service. There may be, if it's on the medical side, there may be laws in place that prevent you from simply cutting off without 30 days notice. If it's your basic, I'm selling you goods, cut them off.
Mm-hmm. Okay.
Internet is interesting, though. I would tend to think that it would be dangerous to merely cut off. I think that you've got to give them perhaps 30 days notice that you're going to take an action before you actually do.
Well, that actually makes, very good sense as far as, having it written in the contract that I guess is what they call the termination clauses within a contract or for a, use of service, terms of service kind of a contract and something like that. But always, communicate with the customer, let them know what your intentions are before you actually do anything. Are there any, let's say a business owner doesn't do that, what kind of risk could they be faced with if they happen to turn off a service? Again, we're looking at web-based or internet type of services, things of that nature, software services, where a person may be either subscribing to a service or a product. Are there legal risks to the owners of the company if they just terminate those services without having it properly stated within a contract or with the communication? Either one. Francine, Elliot. Did I lose you guys?
Oh, yeah. I was wondering where I went.
Oh, okay.
No.
I thought I hit the mute button on the whole session.
No. Elliot, go ahead. This is your area of expertise.
Which part?
All of
it. Last thing
it.
I heard was internet.
Okay. Sorry about that. So what I was asking is that if a company or a business owner really didn't have an ironclad contract with it where it said that he could turn off the services or disconnect the person from using it for non-payment, what kind of risk or legal ramifications could that business owner face if they just turn off that service or cut them off?
The old saying is anybody with a pen can sue anybody else for anything. So you want to avoid a situation where a now disgruntled customer who didn't pay you in the first place turns around and sues you for breach of the agreement that you're trying to get paid for. In my mind,
Look, I think, too, Fred, you mentioned the Internet, right? People go on the Internet and complain that the chicken Kung Pao is too spicy when it's expected to be spicy. They'll complain about anything. So you want to be careful that when you do things that you've given, like Elliot was saying before, give a heads up that this is going to happen. Be careful about surprising people with bad things, because they tend to then surprise you with bad things on the Internet. And you're going to end up paying someone a lot of money on reputation management from a web point of view to get the SEO back after someone has badmouthed you on 5 or 6 different websites, right? So it's important to have good communication and let people know where we are in the process, what we need to do, how you can remedy this, steps that need to be taken. I think you want to be careful about surprising people because, as I said, they'll surprise you back, and you don't want that.
Yeah, sometimes they say what goes around comes around, sometimes harder.
Yep.
All right, so let's go on to our next series of questions, all right? And this is kind of dealing with, contracts and employees as well. With independent and temporary workers, should I have an employment contract, and are there any specific things that should be in that contract to help, protect the business? So, Francine, I think this is more in your wheelhouse, so I'm going to let you start.
Oh, thank you. So if you have a temporary worker, and they're truly a temp, they're coming in for 1 or 2 days while someone is sick, most of the time you're going to be bringing them in through a staffing service. At least that's my assumption, in which case you don't need to have any type of agreement. If perhaps you're saying, okay, I'm going to bring in my cousin to fill in for 2 days, again, as long as it is a very short, and I'm talking 1 day, 2 day, not you're going to fill in for someone while they're on maternity leave for 6 weeks, 8 weeks, 3 months. But in the short term, I don't think you need to do that, especially if you use a staffing agency. However, if you are bringing in someone to do work on an occasional basis, and you intend to do that over a period of time, for example, you're bringing in a web designer or a social media manager, and I'm going to bring them in one day this week, I'm going to have them come in one day 2 weeks from now, and they're going to be doing periodic work on my behalf to help me keep up with my postings on Twitter and on Facebook. In those cases, then absolutely you want to have an agreement with them, because what you don't want is for them to think that they're your employee. And then if they think that they're your employee, then we can have a situation where the Department of Labor and the IRS agrees with them. So you should have an agreement. And one of the very most important things that that agreement will say, Fred, is, hi, I'm an independent contractor. And we will set it out very clearly that they understand that they're not an employee, they acknowledge that, and that they meet the test of what a non-employee is. And that's simply that they can take other work, that you don't have control over their day-to-day activities. They're not part of your business. You're not giving them a company credit card. You're not giving them a business card. You're not assigning them a workstation at your office. So there are different tests that you can meet to show that they're not really an employee. But if you have someone on a periodic basis coming in, you definitely want an agreement, and you want to sit down with an attorney to draft one and not just find some Frankenstein thing that you've created off the internet.
Okay. Frankenstein. I like that. But that also leads right into the next question. As far as, an independent employee, I think of, 1099 employees. So, there are certain requirements in order for an employee to be, I guess, classified differently as, a temporary employee versus an independent employee or a regular employee, how they're paid by 1099. But I think there's a number of things that a business owner shouldn't do that may mitigate the fact that they are a contract employee. So that's one of the points that you brought up in the previous meeting a couple of months ago. So I wanted you to explain or elaborate on that a little bit more.
Be happy to. So the IRS has a 20-question guideline for you to ask if someone is an employee or not. And I believe I gave that out before, and Fred, I can certainly give you a link or a PDF of those questions because they're helpful as you decide whether or not someone is or is not an independent contractor. But basically it goes down to control, direction, and supervision of an employee or of a worker. And so questions come up like, what shouldn't you do? I said a couple of them before. Don't give them a business card. Don't give them a title in your firm. Don't give them company resources to use. For example, don't give them a laptop or an iPad or a cell phone for them to carry around while they do work for you. Don't have them come in on a set schedule like you would with an employee, where I expect my employees to be in from 9 to 5. That's the core business hours. An independent contractor is someone who can have some much more flexibility of time, because what you're trying to show is that you acknowledge they have other clients. That's an independent contractor. An independent contractor is someone who is selling their services to multiple businesses and getting paid that way. And they're making their living by doing that. They are not making their living by only working for you, only coming to your events, only, doing work on your behalf. And that's the real key thing, is you don't want to have the control, the custody, the direction of them.
Can you put, let's say like quotas and requirements on independent employees, X number of sales you have to generate during a period or whatever? Can you associate any kind of performance review on an independent employer, or is that kind of now making them an employee?
Well, we wouldn't call it a performance review, right? We would say that I'm hiring you, and you are in charge. If it's an independent commission salesperson, then you have targets that you have to hit, and I pay you for that. And if you don't do that, then I have the right to cancel the contract with you because you're not performing your services. I wouldn't call it a performance review. I would just say you breached the contract. You were supposed to bring me in 4 qualified leads every week, and you didn't. And so, of course you can have benchmarks. You can have deliverables that an independent contractor must make. But again, it's not that I'm standing there over their shoulder telling them that they must do it a certain way at a certain time with my resources. It's not that. Does that clarify it for you, Fred?
Oh, absolutely. Again, the difference between a benchmark and, sitting down and beating up somebody every single month because they haven't met quota is 2 different things. That's night and day.
Right.
But it's also good to hear it because I think a lot of business owners need to realize that an independent contractor is not an employee, and therefore they can't treat them like that, and they have to, abide by certain rules and regulations. Otherwise, it's going to come back on the business.
You don't want it to, because there are penalties that come both from the IRS, the DOL, and the New York State tax authorities, which can be very substantial and require you to pay disability, workers' comp, FICA taxes. It can require you to have offered them benefits, and to the extent that they would have participated, for example, if you have a 401k plan with employer match, then they could require you to make contributions. It can be really bad. You don't want to get this wrong, and so you want to think very carefully about whether someone is really an employee or not, and make sure they know if they're an employee or not. So. Yeah.
There was one thing you mentioned as far as don't give them things like a business card. Now, I would have to think that, most people who hire an independent contractor don't give it a second thought. And they look at it and say, okay, I'm going to give them a business card. Yeah, you have a business card with my name. You're an independent contractor. And that's more for, fine, brand recognition or company recognition. But by simply doing that and providing them with a business card, you are actually have a potential of breaking that independent status.
Right. So if you insist on giving them a business card, there are ways to try and mitigate this so it's not so bad, where you write things on that business card that says, like, independent consultant on behalf of Acme Inc., right? And so you try and put right on the card the independent contractor's status and call it out. So there are some things you can do that help fix that somewhat, but I tend to be conservative, so I tend to say you shouldn't give them a business card whatsoever.
Okay, so moving on, it's like, how do I protect the company's intellectual property? That's an interesting one because that could be all over the gamut. It could be anything from paper files to digital files to all kind of things. So,
Fred, that's
how do we do that?
That's a 1-hour program unto itself.
Okay, so we're going to have another show. All right.
Look,
so
it's important that you let people know that you believe you have intellectual property that's worth protecting, right? So your employees should be aware that there are things that they are not supposed to disclose outside of the company. And the way you can communicate that to them is multiple ways. One is in your offer letter to them. You can put in a confidentiality agreement and say, look, while you work with us, you're going to be exposed to client lists, to trade secrets, to our business processes, to our target and marketing, our financials, and you're going to be required to maintain the confidence of the company and not disclose that. So you can put it right there in the offer letter, and they have to sign it even to become an employee. Then I would also put it in an employee handbook. And a lot of small businesses forego employee handbooks, and that's really a detriment to them because employee handbooks are not exceedingly costly to put in place. And as Elliot was talking about before, we look at, what's going to protect you should there ever be litigation or a problem. An employee handbook is an excellent tool for an employer to have to say, here are the rules of the road. This is how our company operates. This is what we expect of you. And by delivering an employee handbook to them on the day that they first start working with you and then annually thereafter, and having them sign and acknowledge that they got it, you are telling them again, here's our intellectual property, here's what we expect you to protect, and you do that. Beyond that, you have NDAs, non-disclosure agreements, with clients, with vendors, with others, and there's a whole host. As Elliot said, we could talk for an hour and just be scratching the surface about how to protect your intellectual property. But if I'm looking at it just from an employee perspective, I'm going to build it in my offer letter, I'm going to put it in my employee handbook, and I'm going to remind people that there are things we do that make us great, and we don't tell everyone the secret sauce outside of the company.
Well, we're going to have to do that.
And sometimes don't look at it as what's important to you. Look at it as to what information is important to somebody else. So as much
Good point.
Because we look at it from the employee perspective, you will be exposed to X, Y, and Z, and non-disclosure agreement says you will not repeat it. Also, you have these licenses to use your product at somebody else's place of business. You've got to build in a similar non-disclosure agreement into that license agreement.
So, again, with the world going to the Internet of Things and terms of service, terms of use, and things of that nature, that's where that terminology should also be embedded in those contracts.
And also actually
Correct.
Go file for patents, trademarks, and copyrights.
Mm-hmm.
Preserve what's yours.
Okay, excellent, good. And we will come back and have a show on the intellectual properties. The last topic for our show for tonight is non-compete agreements enforceable? And we see them all the time, non-compete clauses within the employee contract. Generally in sales organizations, that's where it's more prevalent. But, how enforceable are non-compete agreements, and what should a business owner do to help protect his business or his assets in regards to, non-compete agreements? So who wants to go first?
Non-compete agreements are interesting. They can be very scary when you are presented with them, and they can also be used as a threat by employers to employees. New York State courts are somewhat reluctant to enforce them, especially when they are ridiculous, and I've seen a lot of them. For example, if you as an employer put in a non-compete in someone's contract or offer letter or the handbook or any place that you deliver it to them, and you say you can't do these services for 5 years and within the United States, that's going to get tossed out. It's way too broad. The court looks at the geographic area that you are prohibiting someone from working in and the length of time in which you are prohibiting them. And finally, they're looking at, is there any compensation for that person in not performing these services? Now, that compensation can be so attributed at the beginning with the hiring process, where I say, I'm going to pay you X amount of money, and in return for this job at that pay level, you're going to sign a non-compete that says you can't do these same services for a period of time afterwards. So it doesn't have to be that you necessarily pay them post-termination, but you have to make sure that there's an understanding by that person that they are being compensated for the time that they're unable to work. So there has to be compensation. 2, it has to be reasonable in scope and duration. The courts look at what the nature of the business is to determine whether or not the geographic requirement is being met. So if you tell someone who is a barber and they sell you their barber shop that they can't open a new one within 5 miles, right, because you don't want them to just move down the street and begin competing with you, that's going to be most likely enforceable. If you tell them they can't do that in New York State, you're probably going to have a little bit harder time. If you tell them they can't do it for 3 months, you shouldn't have a problem. If you tell them they can't do it for 5 years, you may have a much more difficult time. I always counsel my clients that if they start looking at beyond a 6-month non-compete, and if they're looking to do something broader than, say, Nassau County or Suffolk County or whatever county you're operating in, then you really, you certainly want to be talking with a lawyer throughout the whole process. But you want to sit down with a lawyer and really talk about what are the objectives you're trying to achieve. How is it that by prohibiting this person from working in their given industry that you are accomplishing by doing that? There are other ways of getting to a lot of the same pieces of the pie. Rather than prohibiting them from earning a living, you can have a confidentiality agreement, which you enforce, and you can also have what's called a non-solicitation. A non-solicitation agreement is very helpful. I can say you can't solicit any of my clients or any of the suppliers that I have feeding me for, raw goods or services. You can't go after them for a period of time. Courts are far more likely to help you enforce a non-solicit than a non-compete because New York State is a right-to-work state, and we believe that people should be able to earn a living and feed their family and live in a house. So by doing a non-solicit, you can oftentimes achieve the same objective or very close to it than by outright prohibiting them from doing work.
It's a very good point. And that non-solicit, because I've seen some non-compete clauses, had to deal with some of them over my time. And I always found it's like, wait a minute, how can you stop me from making a living? I'm in sales. I sell office equipment. How can you stop me from selling office equipment in the state of New York for a period of several years?
Exactly.
To me, that was, so, and I think most people would look at that and say, okay, yeah, you can't do that, but I'm going to work here anyway. But there was one thing interesting that you said as far as the compensation. And I think employers and business owners need to think about that as far as, if you're going to do a non-compete, I don't want you to compete for certain reasons, but if the salary that you're giving me and the compensation that I'm going to earn for you while I'm working with you is on par or equal to everybody else in the industry, or maybe even less, but nowhere near, like the salary's twice as much. I'm making 2 times more commission and things of that nature by working with you. Then these non-compete agreements, kind of, don't have any teeth because it's like you said, if the judge looks at it or if it goes legal, the first thing is like, okay, what did you give this employee versus what everybody else is giving that employee? And if your salary is the same, the compensation is the same, what are you trying to protect?
Right. Now, courts have said that just simply having a job can be considered the compensation in and of itself. But you're right, Fred, that when you get a good judge and you have a good lawyer arguing your case for why this non-compete is invalid, they're going to point out, that there's really no compensation for it and that it was inappropriate. The flip side is if you are a business that really wants to protect, your client base and your knowledge, and you really don't want someone to work against you at a competitor, the safest way to enforce a non-compete is to pay them to sit out for a period of time. Now, I know a lot of small businesses can't do that, but if you are willing to pay them their salary for some period of time, you can enforce a non-compete against them. And the courts will look very hard at that because they'll say, okay, you aren't being harmed, ex-employee.
Mm-hmm.
You're getting a salary just like you would have, and you have the benefit of not having to work, right? Now, I know that's something that a lot of small businesses can't do, but that's a way to make a non-compete unassailable.
All right. Well, excellent.
Industry where non-competes are completely unenforceable.
Is there an industry where there's non-competes or none?
Attorneys, yes.
Attorneys.
How come you guys get special treatment?
Well, the reason why is we have ethical obligations by nature of our profession, Fred. So I'm never allowed to work in contravention to any of my prior clients. And so because of that, trying to put a non-compete on me doesn't matter because I could never act against their best interest, whether they are still my client or not. So that's why a non-compete against an attorney is unenforceable.
Okay.
The premise is that clients should always be free to choose the attorney they want. That's where it comes from.
Interesting. Very interesting. Well, excellent. Well, we are at the end of the show, and we've gone over. I usually try to keep this within a half an hour, but there's a lot of information, and like I said, we're probably going to have and revisit some of these topics later on. If there were questions that were asked, we kind of covered them all, so I'm not going to repeat them all. In closing, do either one of you have any closing comments that you would like to say? Elliot, you want to go first?
I always enjoy working with Francine and with you, Fred. It was my pleasure to be on the show.
All right. Thank you very much. I appreciate that. Francine, any closing remarks?
Thank you for this opportunity, Fred. The LIASB is just a terrific resource. I'm so glad to be a part of it and to get to help support your educational opportunities. I'm glad to get to work with Elliot and help bring some of our knowledge here to you. And thank you for the time.
All right. Well, no, I thank you for making the time and providing some valuable information. And for those viewing, Francine and Elliot's information is on your screen, and I'm sure they would not object if you wanted to reach out to them and ask them anything related to our topics or even more than that. They would welcome your call. So please feel free to reach out to them. All right. So in closing, I just want to say thank you to our corporate sponsors, Adelphi University, TBC, the Business Corners, Sorrento Calamar CPAs, and BBA Photography Corporation. I want to thank everybody and thank our guests for appearing tonight. This has been Overtime, LIASB's online business development series. Everyone, have a great night, and we'll see you next time.